Hello and welcome to Hot Issues. Today we are talking about pensions. Indeed, we're talking about the second-tier pensions, which has become such a controversial issue and a bone of contention between sections of organized labor and the government of Ghana. We want to find out what it's all about, what the legal position is, and perhaps what the way forward may be. Welcome to Hot Issues. We are indeed privileged to have with us in the studio a lecturer in law at JIMPA, Mr. Ernest Kofi Abotsi. Sir, welcome to the studio.
Thank you.
How do you understand what is going on between government and workers and so on from the legal perspective?
Well, from the legal perspective, clearly it seems that organized labor thinks it has a certain right against government in respect of the management and, if you like, the investment of resources that would become their pensions when employees do go on pension. Clearly, on the side of government interprets the law otherwise. It is useful to mention that we have evolved and come from a certain historical experience, and Cap 30, which used to be the norm before, probably didn't have these divisions in terms of tiers, among others. The current Pension Act, Act 766, establishes a three-layered arrangement as far as pensions are concerned, and it seems that organized labor just wants to take advantage of that structured layout and to assert a certain right in respect of the second tier option, as you mentioned in the introduction. So clearly what we have, legally speaking, at this stage has to do with the question of who really has a right or a certain right in respect of decision taking as far as the second tier option is concerned. Decision taking in respect of its management, in respect of its custody, in respect of its trust, and the other issues that are articulated under Act 766. Generally, that appears to be the basis of the conflict between organized labor and government.
Whose rights should be affirmed in this matter?
You're putting me in a dangerous situation.
No.
Well, first of all, it's useful to mention that this matter is before the courts. And so whatever statements I make here and whatever statements we make is in the context of some academic, intellectual understanding and elucidation of the law, not to necessarily prejudice the outcome of what is before court. It is a complex issue, and I need to state from the outset that we are evolving, and that evolution necessarily would harbor some conflict. The conflict reflects an evolving understanding itself, and I'm just going to share my perspectives as far as the position of the law is concerned. Act 766, in respect of the second tier pension, states clearly that there's going to be a contribution by employers. That contribution will be made on behalf of employees, and therefore it can be split into two. There is a beneficiary. The beneficiary is the employee, but the one who has an obligation to make a contribution in respect of that is the employer on behalf of the employee. Of course, a component of the amount that is actually paid is paid from the salary of the employee, and then an additional contribution made by the employer, so to speak. The law clearly seems to create an obligation on behalf of the employee, but incumbent on the employer. The question, and I think that is the central basis of the argument and the confusion, as to who makes a decision in respect of where and how that payment is made, in respect of the custodian, in respect of the trusteeship, among others. Who makes a decision in respect of that? In the argument of the employees, as I understand it so far, they are the beneficiaries, they are ultimate beneficiaries. As an ultimate beneficiary, you should necessarily and naturally have a certain right to make a decision in respect of the deployment and, if you like, use of that resource, since ultimately an improper decision exercised in this respect would be to your disadvantage. So that makes some logical sense, and that is the argument by the employees. The argument by employers is that not only traditionally has it been the responsibility of government, in this case government, not only has it been traditionally the responsibility of government, but indeed Act 766 clearly mandates government to make that decision on behalf of the employees. In fairness to both parties, and I think on the balance, looking carefully at the structure of the Act, the Act itself leaves the issue open and without answer. And it does seem that certain aspects of the Act may implicate broader questions which may be in favor of government to a limited extent. And the reason I say this is this: that if you look, for instance, at specific sections, including Section 3 of the Act, the expression "on behalf of the employee" is actually used. If you look at the definition sections of the Act in respect of who an employer is, among others, there is no doubt we're dealing with government, because Section 211, for example, clearly says an employer two ways. One, an employer is someone who probably owns an establishment, or two, an employer is someone who has a contract of service with another person, and in respect of which that person has a responsibility of payment. If you look at the public sector, clearly this description fits government fair and squarely. I think, therefore, that the context of who an employee is, among others, appears to be resolved in favor of government, and therefore government as an employer in this particular context. The question as to whether or not government has the right to appoint the trustee and the custodian and the managers of the resources is a question that, legally speaking, may appear to be resolved again in favor of government, if you look at my understanding, my reading of the law as it stands. But the question is, we cannot deal with this issue just in the narrow context in which we probably are looking at it now. And the reason I say this is, for the final and just resolution of this, we probably have to look at the broader context. And I think government, obviously, for all its responsibilities, may want to exercise some responsibility in looking at things not purely from the legalese perspective, but to address surrounding concerns. The fact that there has been a deficit of trust between government and employees is a historical matter in this country. The fact that governments over the years have failed, if not refused, to address fundamental issues of pension, the issue of the non-economic viability of pensions that are paid to people, and the fact that people who receive pensions could barely ever survive on these pensions. These are historical things that have not been dealt with. And the fact in recent times that pension fund administrators and managers, particularly of the first year, and I'm talking about SNIT, the fact that there has been numerous complaints about SNIT, whether or not they are justified or otherwise, the fact that these have not been structurally addressed, all have lent themselves to the persistence of these suspicions and the lack of trust between government as an employer and its employees. And I think that until this is addressed, we cannot ignore the political angle to this. It's not a purely legal issue. It is a legal political issue. And I think that a proper and a final resolution to this would involve an understanding of this dynamic. Otherwise, you look at only one aspect of it, and I think you will be failing to address the issue in a holistic manner.
Well, if we have to go beyond the law in resolving some of these issues, if we have to look at these issues not purely as legal issues and so on, how far beyond the law can we go?
This is how far you can go. I need to just state this, and sometimes when you say these things and you don't clarify well, then it has its own cascading effect. I need to state that trade unions, and I know you know this, trade unions have essentially been political instruments. Indeed, if you do an investigation into the origins of trade unions started globally as political pressure groups. And that is why in many countries, including Britain, trade unions eventually metamorphosed into political parties. So you have workers' parties, and they call Labour, among others. In many countries, you have workers' parties, because workers, by virtue of the force, the political force they exert, and by virtue of the fact that indeed they can actually bring the operation of a country to an end and to a standstill, a halt, workers have traditionally always exerted a very significant political influence as far as the governance space is concerned. It is in this context that any issue dealing with workers would have to be addressed from that holistic perspective. I think understanding this just from a purely legal perspective without looking at the political context may distort some of the discussions. I think that legally speaking, as I indicated, it is my very humble opinion that legally speaking, government is the employer contemplated under the Act to make an appointment in terms of who the trustee, among others, is. But in so doing, some democratic consultation is useful. You beat down the suspicions, you beat down the allegations, and so we probably want to look at expanding the space for consultation, because the question is this, and I do believe the governments always mean well, and government of today means well in terms of ensuring that its employees have a certain stability of earnings post-retirement. Government, I believe, means well that in the end, the amount of money received by its employees when they go on retirement does not lead to any social dislocation, because the consequence of any failure to have proper pensions ultimately gets back to government in the character of social dislocations and social welfare issues. And so ultimately, it even shows the reason why the Act itself has placed that responsibility on government. Because let's put it this way, there is a justification for creating, if you like, a patrimonial relationship between the government as an employer and employees. And by patrimonial, I mean, like paternalistic, a father and a son relationship, where father knows best as opposed to what son. So son wants the money to go and misuse. Father says, no, I'm going to put it to this good use. And by that, I'm not suggesting that workers want to misuse the money. But workers may probably, in the light of all the suspicions and all the historical problems between government and workers or suspicions, workers may probably think that they're in the best position to apply these money on their own behalf and therefore decide who becomes the manager and who becomes the trustee, among others. However, government, with its machinery, with its expertise, with its capacity to, as it were, audit and review and select the best among the lot to do this management, among others, may be in a much better position to do that. That is a separate issue from saying that government traditionally has not been sensitive to the proper management of these. So we can ask, moving forward, can government better do this in terms of managing these resources, in terms of using its leverage to ensure that these things are properly managed and that the returns on workers' pension is great, and therefore they are much better catered for. And then, having failed to do that in the future, how do we ensure that government now gets alive to its responsibilities? So clearly, SNIT may be an example of how government may not have succeeded over the years in demonstrating their commitment to pensions moving forward. But having seen that problem, how do we overcome that? Because the fact that you take it for government of itself does not resolve the issue. We should not forget, and again, I'm not imputing anything to anybody, and I need to be clear on that. We should not forget the fact that the leadership of unions themselves may not necessarily be disinterested in terms of the deployment of resources, among others. Again, I'm not limiting myself to the leadership of the current union, but I'm speaking in a very generic sense. Trade union leaders the world over have had accusations also leveled at them. So the fact that the leadership of unions may themselves want to, say, make a choice, the same accusation that is being applied to government can be applied to the trade unions, among others. That
I was going to come to that.
I mean, these distortions are there, and I'm not just suggesting again that anybody has any questions, but speaking generally and speaking in objective terms, I think it's important for us to look at the issues a bit less emotively. I can understand, and I have to be very honest about this, I can understand the concerns of the trade unions and of workers generally, that what is the record? The past record is not particularly good.
But that record, unfortunately, is not a record of government alone.
Correct.
It's a record of government and the unions, because the unions were represented on the SNIT board.
Correct. So it is a collective responsibility, it is a collective record, and it is a moment and an opportunity for introspection. So the question is this: where have we gone wrong so far? How and what are the opportunities presented by this current arrangement? How do we exploit these opportunities in order to ensure that these mistakes and errors of the past are not repeated? Doing that, I think, overcoming these is not something I think we can arrive at if we proceed the way we are proceeding. We have to admit certain facts. One, there's a trust deficit. There's no doubt about that. There's a major trust deficit between government and workers.
I think that's a mutual trust deficit.
It is, well, on both sides, but on the part of the unions, probably they have not managed anything for government. So the trust deficit.
But it is many things for workers. Many things for workers throughout the world. The accusation that organized labor or the leadership of organized labor has often mismanaged workers' funds is there. I mean, if you take the Trades Union Congress, for example, the Labor Enterprises Trust, for example, is one big example.
That accusation is cross-cutting, and I'm sure it can be found on both ends. And I certainly probably agree with you to an extent that yes, there has been accusation of leadership not having probably exercised much responsibility when it comes to their constituents. But playing the devil's advocate, the response I'm sure that from the leadership of the trade unions will be that, well, they answer to their constituents, and if their constituents are fine with them, an external agency cannot hold them to account for matters internal, in respect of which they have not been accused of as far as the constituents are concerned. But again, that argument
that's a faulty argument.
Well, again,
it's a faulty argument to the extent that if labor leaders, for example, and for the purposes of this argument, steal from their members, ultimately it's the state which prosecutes them.
Absolutely, the state prosecutes everyone for, I don't want us to stretch this. I totally agree with you on a point, but the point I'm making is, playing the devil's advocate, I can even support what you're saying, that traditionally people in their disaggregated mass do not do well in holding people to account. So you can have so many thousands of workers who believe that things are not going right as far as our union is concerned, but they are so disaggregated, it's so hard to get them together to be able to hold a group of people to account. So that could be one weakness as far as that accountability mechanism is concerned, which supports then your position.
But that weakness is also a weakness with government management as well. Because people again are disaggregated.
Correct.
When they're dealing with government.
Correct.
Not just the unions.
Correct.
Yeah.
So there are weaknesses and there are fault lines as far as the various sides of the arguments is concerned. Moving forward, and again, being sure of where we stand in order to know how we move. The question is, how do we address some of these fundamental weaknesses as far as the arrangement and relationship structure is concerned? And how do we then exploit these in the context of the law? The fundamental policy that informs, in my opinion, the adoption of the current arrangement is to put government in a responsibility position, but unlike the previous position, unlike the previous arrangement, to disentangle and fragment the various components as far as the management is concerned. So the trustee is not the same as the custodian is not the same as the fund manager. In the previous arrangement, SNIT was all in all, and in the light of its relationship, subject only to ministerial directives and subject only to the political, if you like, ultimate political hierarchy, the trust deficit was further reinforced, because workers will say ultimately our resources, ultimately all our money ends up in the hands of an entity which responds to government and which reports to government. And if that government, the same government will have issues as far as the management is concerned, is the ultimate oversight responsibility of states, then there's a problem. In this case, there has been an attempt to ensure that even if you have government being the larger employer, government doesn't do the management, government doesn't do the trust oversight as far as the management is concerned, and government doesn't keep the resources as custodian. So there's government.
Ultimately, it comes back to government. If these private companies which are acting as trustees, managers, and retainers of the funds and so on go bust, who ultimately becomes responsible for the pensions of workers?
That argument again is both ways, and we should. I'm trying so hard for us to avoid distorting the facts. The point is this: if, for instance, government appoint Company X as custodians, and Company X is liquidated, Company X is keeping the funds on behalf of workers contributed to by government, but Company X is going bust, will obviously create liability issues and questions of who owns, who bears which liability for the fund going waste. Clearly, government, having made judgment in respect of choosing Company X, would have had to bear some responsibility for choosing Company X, which ultimately goes bust. But that argument can be stretched and applied on all angles. If private entities, or let's say workers, decide to select Company Z, Company Z can go bust. If Company Z goes bust, again, ultimately the question of liability and the question of the dilution and the ultimate destruction of the pensions of these workers ultimately still again comes back to government.
Exactly.
There must be a way out, and that is why I am saying that the consultative process is what probably has to be deepened now. Because the question is this: if government invests in company, if government chooses company X, and company X's modalities of operating and the trustees' judgments in terms of investments are all going to affect ultimately the quantum of pension payable, and workers think that we have a brilliant idea, and that brilliant idea means that we should select company, say Y, and company Y is likely to bring us much better returns, and government and workers can judge, or probably they can get to a point where the selection criteria and the selection process can lead to the selection of a company or an entity in respect of which all the parties are satisfied with. Of course, there's always a risk, but in the end, when the risk comes, there's a certain satisfaction that there was an input in the process. We have exercised the best of judgment, and that best of judgment did not end up well.
You put it so nicely. You put it so nicely. But is that really the situation? Because my understanding is that all of these companies are just taking monies from government as contributions to workers' pensions. And then they're lending the monies back to the same government, making an interest and sharing the money. That's all that is happening.
Okay.
They take the money, they invest it in treasury bills, which is lending to the same government from which they're taking the money, and then they make a cut. That's all that is happening.
Well, again, for me, I'm trying so hard to stay a little bit away from the specifics, which can then lead to more assertions and disputations, because I'm sure the facts are a lot, and a lot have not been agreed upon, and no court has made a definitive pronouncement. So a lot are rumors and suspicions. They could be true. I am not aware of those, so I'm not going to make any definitive statement as far as some of these positions are concerned in terms of whether money is taken, giving back to government, taking money from government and giving back to government.
They take money from government and invest them in treasury bills. Right. They're lending them back to the same government from which you took the money.
Correct.
And making a cut, really, for no work done.
Correct. And that is why, Kwesi, I will come back to the position of the consultative process. The question is, if you are going to invest my resources, and by my resources I'm referring to money given by government on behalf of employees, and that money being given to a particular fund manager or a particular trustee,
or custodian.
Right, or custodian. I am speaking from that perspective that if we can expand the consultative process, I think at this stage the law doesn't make it incumbent on government to consult, if you ask me. At this stage, if we speak legally, government has the right. So there is no issue of whether or not the government can do that. The government can do that. But we're speaking from a certain context, from a certain historical context, and from a certain reality of a government's employee dynamic, which reflects a certain degree of trust deficit. And I'm saying that overcoming that, curing that, and ensuring a stable relationship between these stakeholders. Ultimately, they are stakeholders. Ultimately, government wants to ensure that its employees or its former employees on retirement receive good pensions. Ultimately, employees want to ensure that their future is guaranteed and safe. There is a mutuality and commonality of interest. The deployment of that interest and the enforcement of that interest is what we have to try and ensure, that the process is not only transparent, but the process is also consultative. And I'm thinking that probably part of the reason we have the current situation is because the consultation process has not been that expanded. And the reason partly may be also due to the fact that government may be thinking of business as usual. It has been the past. We are government, we are employers, we invest on your behalf. And I think it is that context of deficit vis-a-vis the lack of consultation which is creating the problem. I think government as employer and employees must recognize two things. One, at this stage, in my opinion, government has the right to make a decision on who the trustee is. And then two, employees have a right as the ultimate beneficiaries to have a certain say as far as the deployment through the fund manager and the trustee, among others, the custodian. to have a say also, because ultimately, given the scenario you gave, a failure of a choice, i.e. leading to an improper choice, would have cataclysmic effects on both ends. Government would have to still find a way of dealing with the loss of pension for its employees because of the wrongful choice of, say, a trustee, among others. And employees would have to find a way of dealing with the difficulty and the pain of having to take, say, less pension or even no pension at all because of, again, the improper. So there's a mutuality and commonality of interest, and I think both parties need to have a constructive understanding of that. I think if they do, there's likely to be a progress moving forward.
We'd like to find out whether we could have avoided getting to this stage of an apparent, stalemate between government and the organized, workers, organized labor. Sir?
Well, you put the question earlier before we went on break, so I know what you're asking. Again, it is useful for us to put things or situate things in context. The relationship between government and employees have traditionally in this country, and rather unfortunately, been conflictual in outlook. When workers have an interest, they tend to speak to government as if they are warning government, which is funny because then one would expect that the relationship, being an ongoing and stable one, should have constructive mechanisms of articulating concerns and grievances. When it gets to warnings and threats of strikes, then you know that clearly at that point you've already gotten to a level of breakdown before something could be salvaged. On the other hand, the complaints traditionally have been that when government is informed of worker concerns, there's minimal response, or even sometimes a complete shunning of worker concerns. I think, again, as I indicated earlier, this may probably explain why there's such a deficit between the two parties, as far as trust, as far as confidence in each of the parties supporting, respecting, and protecting their respective interests. I think that it is one thing that really needs to be worked upon, because government still remains the single largest employer of workers. In that light, we cannot continue in this conflictual relationship. Clearly, government has concerns. Clearly, workers have their own concerns. I'm sure both parties can state their concerns in a very strong manner that can probably even out, if not cancel each other out. But the question is, moving forward, the state, which is ultimately the loser in any such conflict as currently we're experiencing, that dictates that especially government, being the custodian and being the custodian of power and the repository of power, should probably moving forward, start thinking of reinforcing the mechanisms of consultation, dialogue, and sustained relationship in the background. I think over the years we've had too many instances of strikes and sometimes lockouts, which have been disruptive for the operations of government, for the operations of the state. And I think that particularly this pensions problem may provide an opportunity for some learning, because clearly it's a new experience, and I'm sure that for many of the people who are following and the stakeholders who are following the events, I'm sure there's a lot of learning going on, and one would hope that clearly government and the workers would both come out better learned and better motivated to put in place mechanisms to ensure this doesn't happen.
Government has said that this strike is illegal, and the ruling by the National Labour Commission appears to affirm that. In this context, what is legal and what is illegal in strike actions?
Okay. An illegal strike is simply a strike that has been embarked upon in contravention of the Labour Act. The Labour Act has put in place mechanisms of redress for grievances. These mechanisms are generally what lawyers will call alternative dispute resolution mechanisms. By the Labour Act, strictly speaking, there can never be a legal strike in this country that goes beyond 7 days. Never. Now, there can hardly also be a strike that would have there can hardly also have been a dispute that would have escalated to the point of a strike even for that 7 days, because there are mechanisms of negotiation, mediation, and then what is called voluntary arbitration, and then what is also called cooling off. The cooling off allows you an opportunity to, as the name suggests, to cool off. So there's a period where both parties are not supposed to declare strike. You're supposed to reflect, and if within the time of cooling off, there has not been an agreement, then parties are allowed to declare strike. Very limited number of days, as I indicated, and after that, you have to submit yourself to what is called compulsory arbitration. The compulsory arbitration is supposed to come out with a decision. So there must be an outcome. And that outcome is binding on the parties. What it means, therefore, is that there's a binding process of alternative dispute resolution which would ultimately result in an outcome. And that outcome cannot be deviated from by either parties. And so technically, no party can go on a strike that can last beyond 7 days.
But this strike is going beyond 7 days.
Well, even before it gets beyond 7 days, the question is whether they complied with this mandatory process of resolving conflicts, whether the unions have activated the mechanisms of redress under the Labour Act. The Labour Act is supposed to provide an oversight platform for ensuring that this process is gone through. The question is, has the Labour Act been complied with? And if it hasn't been complied with, then clearly, on the face of it, the unions are in violation of the Labour Act. And so, in terms of the law, they have not complied. But as to the effectiveness of the law, that's another story altogether. And as to whether the mechanisms established under the law will have the biting effect to be able to ensure that there's a stability on the labor front, it is useful to understand the origins of the law, because this law, which came into force in 2003, prior to the law coming into force, we all know the situation in this country. Workers were basically holding government to rampage and hostage. They were basically to be holding government to ransom. Just go on strike. If you want something, stay as long as you want. Government will be compelled eventually to do something. And so the shocks, the industrial shocks in the system was really all over the place, particularly in the mid-90s. I'm sure you remember, with the UTAGs that once went on strike for like a whole year, I remember, among others. And I'm sure there are even more of those experiences that you may even remember than I do. With all that background in mind, the Labour Act in 2003 tried to put in place a stable and predictable legal framework for ensuring that workers' agitations are contained within a constructive platform of resolution. But beyond that, we have seen countless instances, the medical fraternity in particular, declaring strikes which are contrary to the Labour Act, and eventually nothing gets done. Of course, one incident happened, I think I can't remember the year, but Nagrat was one of these Nagrat famous strikes that they were actually forced to refund losses incurred by the state for the period they were on strike, because they had embarked on an illegal strike. Indeed, under the Labour Act, an employer has the right to dismiss an employee for failing to comply with the mandatory provisions, for embarking on, say, an illegal strike, among others. So these penalties and consequences are there. Nonetheless, you cannot apply them in a vacuum, because you are dealing with thousands of workers, and the fallout can be cataclysmic, and clearly government has a responsibility it is mindful of. And I suspect all these dynamics shape and influence workers deciding to go on strike and government deciding to react. I think that's what we're witnessing at the moment.
Last Wednesday, government went to the Labour Commission seeking a declaration that the strike was illegal. The Labour Commission came up and said, look, the workers have to resume work immediately. The following day, I heard the General Secretary of Nagrat say that in spite of the decision of the Labour Commission, he has to go back to his council for authority to call off the strike. What is the legal position?
Well, I did not hear that, but taking your report, your lawyer can advise you, but your lawyer doesn't give you authority Authority is from the court.
No, the council.
Council, not lawyer.
Council,
okay.
Not lawyer. Yeah.
Council as a body.
Yeah.
Right. Whoever it is, really, whether it is council as a lawyer or council as a body or any other collegiate body, that body cannot overrule the authority of, say, the National Labour Commission, which is a statutory body, or the decision of a court, for example. Again, I've always tried to speak real politic here. We have to really be realistic sometimes. The Labour Commission has challenges. Sometimes it has to go to court to seek the enforcement of its own declarations. Ultimately, when you have a group of people in their numbers taking a decision and refusing to, if you like, respect or adhere to a decision of a body, sometimes it can be a difficult task, because you do not, of course, want to obtain contempt of courts, for example, an order of contempt of court against, say, thousands of people. Which prisons are you going to fill them with? Or, say, the Labour Commission. But
you can obtain the order against the leadership.
You can obtain
instead of the general membership.
Well, you can obtain the order against the leadership, and I'm trying to be careful not to give a certain advice, because I can give an advice, people can start hiding behind the advice. But the point is this: if the leadership say, well, okay, you guys should go back to work, and the guys say, we're not going back to work, there can be a gulf between the leadership and the rank and file. But the question is, to what extent do the leadership exert an influence in respect to the rank and file, and to what extent do the leadership really mean it when they are convincing the rank and file to go back? Because ultimately the decision to embark upon the strike was taken by the leadership, and therefore the decision to disembark or to call off the strike will have to be taken by the leadership with the same enthusiasm of conviction as far as the rank and file is concerned. But these are complex issues, and I can assure you that the leadership often may not have the motivation to actually get the rank and file involved. That, look, we really have to go back, if they are not interested in doing that. All they will do is probably just show some passive declaration that, look, we are no more interested, you guys should go back, just to avoid the contempt of court consequence. And I suspect, again, that is why sometimes you have, say, government going to court to obtain an order just to compel them to go back, because ultimately the dialogue fails and breaks down sometimes, because let's face it, sometimes worker demands are also unjustified, and sometimes worker demands are also not, predicated on very sound reasons.
There does not appear to be any sign of resolution. What real, concrete, practical steps can we take to get out of this lockdown? Short break.
Well,
concrete practical steps.
Well, this is my suggestion, or these are my suggestions. The reason there are conflicts is because we're seeing at one and the same thing sometimes with different perspectives and eyes. And in order for us to resolve the conflict, we must start shifting from the angles of our differences to the angles of our commonalities and common positions. I think government and organized labor have the same interests, but the articulation of that interest appears to be based on different reasons and different factors and different perspectives, and that probably may be part of the reason, part of the problem. So the question then at this stage is, how do we, first of all, recognize that common interest? Having recognized that common interest, how do we build confidence moving forward? Because I think there's a loss of confidence. It has been there, but I think it has been aggravated, it seems, by a lot of things people have said against each other from the various divides. I think, therefore, that there must be a building of confidence at this stage. I'm glad they've started talking. It is the beginning of the confidence building process. Government and organized labor must recognize that the continued failure to report to work and to work on the part of workers will undermine the long-term effect of even whatever pensions they get, which we are talking about. Government and organized labor again must recognize the fact that until and unless there's a sense of partnership moving forward, this conflictual relationship, which has been characteristic of organized labor and government for well over 50 years, I'm sure, is not going to inure to the benefit, the medium to long-term benefit of the industrial front and our economy in general. I think these recognitions are not too hard to defend and too hard to posit. What is difficult about them is how to get both government and organized labor to start speaking the same language. I will again urge, and it's not something I do because I try to stay away from the free at all. I will just hope and urge that in the interest of building confidence, both parties must make some concessions that they will respectfully take, and that should lead to the end of the strike, while immediate steps are taken to ensure that resolutions are arrived at.
For example, the public may be making its decisions on the basis of the fact that it assumes that it's a normal conflict between organized labor and government. Whereas in reality, it may also be a conflict between companies competing for the same resource.
The fact that there are entities that may have an interest and that may have actually the capacity to influence the process of itself may not be a bad thing. I mean, lobbyists and lobbying has been an integral component of American government, but clearly there are levels at which lobbying even ceases to be lobbying and it becomes corruption, for example. These are complications that we can look at moving forward. What is dangerous is the hijack effect. Mm-hmm. The influence effect itself is not a bad thing, but it is the hijack effect that can become dangerous, i.e. where you have these vested interests actually hijacking the process, so that the people who are perceived to be the participants in the conflict are indeed just a face, and they
may have legitimate
concerns, but then these concerns get hijacked by entities and by bodies and by if you like faceless interests that cannot be identified. That is where the danger actually comes. But again, just to reiterate what I said earlier, at this stage we can only speculate. I do not have any evidence to the effect that certain entities who actually applied, for example, to be appointed trustees and who failed to be appointed are actually funding the conflict. I don't have any evidence to that effect.
No, but the interest is discernible. For example, you have a situation where government is recommending or insisting that pensions, allowance, trust or whatever should manage these funds. You understand?
Right.
On the other hand, if you look at the workers' arrangement, there are companies like Prudential Bank, Data Bank and so on the other side. So the interests are discernible. What we cannot say for sure is whether these competing interests are responsible for the current impasse.
That's the point.
That's what we cannot say.
Exactly.
But the interests are discernible.
It's clear. It's clear. The fact that they have an interest, the fact that they may be the beneficiaries in the event of a decision going one way or the other, or for beneficiaries or losers, if you like, in the event of a decision going one way or the other, these are indisputable. You can't dispute the fact that a company may be very happy, for example, if workers will be allowed to make a choice because they know that the workers are going to come to them, that sort of thing. It's clear that these companies may probably be sitting on a knife edge, hoping and wondering what's going to happen. That you cannot deny. It is a different thing from saying that they may actually be hijacking the process, hiding behind workers to articulate their concerns. That would be a speculation if we do that now. And I think that in the light of,
but it's okay to say that they may be. It is all right to say they may be. What you cannot say is that they are doing it.
Correct. Correct. The fact that they could.
Yeah.
The fact that there's a prospect of they being the one. I mean, it's a probability issue. They could, they may or they may not.
Yeah.
Who knows?
Yeah.
But as to whether they do or as to whether they are, I have zero evidence. And I can't make a speculation.
You cannot say.
There's no way I can make it.
Thank you very much for coming to this.
Thank you very much, Kofi.
Thank you very, very much.